Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 42 in the list of AOR leading cases, and that case is a very well-known case, which is the case of Shayara Bano versus versus Union of India. Now, various writ petitions were filed before the Supreme Court, which were arguing that the practice of halala, that the practice of polygamy and the practice of triple talaq in Muslim law is violative of Article 14 of the Muslim Wives and Muslim Women's. Now, here the court in this case is only predominantly looking at the practice of triple talaq and letting the issues of halala and polygamy for a later adjudication. So, what is halala basically is when a Muslim man divorces his wife. He cannot remarry her, so that woman now is made to marry some other men and then divorced by the second husband, so that in order so that she can marry the first husband or her ex-husband again if he wishes to remarry her. So this practice was considered, was seen to be a violative of Article 14 of the Muslim women. And then when we come to polygamy itself is violative of Article 14, because when we are making legislatures, when we are allowing monogamy to be the rule, why is it that Muslim women are suffering even though we do have legislatures enacted? So that is also in question in this case. However, this debate has been put off for a later discussion by the Supreme Court, and the Supreme Court is bringing only the issue of triple talaq on the tangent of its adjudication. Now, in this case, Supreme Court is determining the constitutionality of triple talaq. Now, what is triple talaq? We need to get in the fundamental of that first. So in Muslim law, it is very well known that talaq is of two kinds: extrajudicial and judicial. So extrajudicial talaq is one which is the right inherited by Muslim husbands. So Muslim husbands do have a right to invoke the talaq extrajudicially just by pronouncing talaq. Now there are two forms of talaq. When we talk of there are many forms of talaq. There is hasan talaq, a hasan talaq, then there is constructive divorce, then there is mubarak, then there is ilaz dihar. We have a lot of forms of divorces in Muslim law to be studied anyway later on, but this case is basically concerned with the triple talaq. Now when I am talking of triple talaq, there are two categories of talaq: extrajudicial talaq, extrajudicial divorce, which is talaq e sunnat and talaq e biddat. Now, when I am talking of talaq e sunnat is here is meaning that this talaq is in good form of talaq, is an acceptable form of talaq, because what is happening, even though Muslim husband is pronouncing talaq, but it is revocable in nature. So it gives the categories under talaq e sunnat are hasan talaq and a hasan talaq, and it gives more or less 3 months for to the husband to reconsider the talaq, and he may uh, revoke the talaq as well. So the opportunity is there with the husband. So if he is pronouncing talaq in a fit of rage, in a fit of anger, he can revoke that within the period of 3 lunar cycles, within the period of 3 months, in a hasan talaq or hasan talaq. But when we come to the second form of extrajudicial divorce, extrajudicial talaq, it is talaq e biddat, which is a practice widely being done in India. And we also know talaq e biddat to be known as triple talaq. Now, in this, what is happening? The husband is pronouncing talaq three times, talaq, 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 and it is irrevocable, because here there is no opportunity of revocation of talaq and of re cohabitation of the Muslim couple. Now, the petitioner here and even the court is taking a suo motu cognizance of this practice in this adjudication. The court here is looking into the constitutionality of the triple talaq. So court here invokes the Shami Mara's judgment, where the court is looking at that the correct law in the Holy Quran is that the talaq must be for a reasonable reason, must be for a reasonable cause, and it should take in account some attempts of reconciliation between the husband and wife by two arbiters, one of which will be from the side of the wife, one of which will be from the side of husband, so that reasonable opportunities are given. Where there is a chance of reconciliation, it must be done. So Shami Mara's case is looking at that, and when we are adjudicating Shaira Bano, we are taking Shami Mara's decision into account. Now, court here is looking at the practice of triple talaq. The practice of triple talaq is, you know, a it is prima facie violative of Article 14 of the Constitution of India with respect to the rights of Muslim women, because it is like just the pronouncement of talaq, three times talaq, and it is being done in fit of rage or fit of anger, and since it cannot be revoked, the women becomes pardon me, women becomes divorced in just a minute, right? So now this is manifestly arbitrary in the sense that marital tie can be broken just in a couple of minutes, just in couple of minutes, and therefore it is violative of article 14 of constitution of India. Now here also one of the aspects of it is the Muslim women who undergoes triple talaq, she is only entitled to receive maintenance for the iddat period. Now iddat period may vary from 3 months to 9 months if the woman is carrying a child, but not beyond that. However, that the maintenance issue has been adjudicated in the case of Shah Bano Begum, but then this used to be the norm. Now what is happening in this case is that once a woman is left after the divorce, it is getting violative of her article 14. Now the argument that has been raised in this case is that article 25 allows a person to profess its religion, and triple talaq, the practices like triple talaq, halala, or polygamy are essentially are part of the Muslim religion, are part of the Islam religion, and Article 25 can be invoked here. So now the court is looking at Article 25, court is reading the language of Article 25, providing that Article 25, when we start reading Article 25, Article 25 starts with subject to. So subject to public health, morality, and decency, and other rights enshrined in Part 3 of the Constitution of India. There is a freedom of professing one's religion. So, Article 25 is also being subjected to the other fundamental rights that are present in the Constitution of India, Article 14 being one of them. Now, court here is also looking into where various schools of Sunni sect and Shia sect in Islam. So in Shia, Hanafi school is practicing triple talaq very prominently, and now it has been it has become an integral part of religious practice, as what is the argument advanced by the sides. Now here court is saying that triple talaq is not an integral part of religious practice, just because it has been committed for so long. The court here is saying that what is not part of theology, what is not part of Quran, what is not part of the core tenet of Islam cannot be converted into law just merely on the basis of the fact that it has been practiced for so long, since so long. Now court here is comparing article 14 and article 25 also, and it is declaring, because of the language of the constitution itself, that article 14 will always be given primacy. Court is also looking at the 1937 Shariat Act, which is Muslim Personal Law Shariat Application Act 1937, in which there is a section providing triple talaq as a form of divorce. Now, court herein is saying that because 1937 Act is a pre-constitutional act, Article 13 will come into picture. That we know that Article 13 says that even if an act is retrospective, even if an act is prospective, it cannot contradict with the fundamental rights. So when Shariat Application Act, Muslim Personal Law Application Act of 1937 is allowing triple talaq as a form of practicing divorce, court herein is saying that that particular section shall be rendered unconstitutional to the extent that it is allowing triple talaq to be a practice. So court herein is invoking Article 142 jurisdiction, holding that the practice of triple talaq shall be abolished, and also directing the Union of India to formulate an act, formulate a legislature to prevent triple talaq cases in future. Now, pursuant to this judgment in 2019, we do have a triple talaq act, which is forbidding the Muslim women, which is forbidding triple talaq with the Muslim women, and it is also making it punishable, right? So in this act is named as Muslim Women. This act is named as Muslim Women Protection of Rights on the Marriage Act, and being enacted in 2019, widely named as the Triple Talaq Act, and it penalizes triple talaq being done by the Muslim men. So that is the influence of this judgment. However, in this case, pardon me. However, in this case, the Supreme Court is not directly touching on the issues of polygamy or halala, but it does believe that somehow they are being touched upon when triple talaq is being touched upon. So if we decrease the practice of triple talaq and we are only accepting Hasan talaq or a Hasan talaq as a valid form of practice, there is a chance of revocation of divorce if divorce is pronounced in a fit of rage or a fit of anger, or in provocation, or whatever the case may be, right? So this was the case, this was the judgment, this was the decision being held in the case of Shayara Bano versus Union of India. I hope this video has been useful for you. I hope the other videos that are there on this channel are useful for you. You are going through them and it is helping you out. I hope that this discussion is serving the purpose. Please stay tuned with us on the channel. Should you have any queries, any feedbacks, any demands for any content to be uploaded, please feel free to write it to us at legaldarshan@gmail.com. The email ID is in the description box below. Thank you everyone for watching. Have a very nice day.